This is day 2 of this panel's sitting. I have the privilege of sitting today with Senior Judge Edith Brown Clement and my colleague, Judge Andrew Oldham. We have 2 cases on the oral argument docket this morning. First of all, Counsel, please be advised that we have read your briefs. We're familiar with the arguments that you've made in the briefs. We're familiar with the pertinent case law that you've cited. So if you could tailor your remarks accordingly, that would be appreciated. Secondly, if you have not argued here before, we have a little lighting system you'll see on the podium. When you begin your remarks, the green light will go on. The yellow light will go on when you have 2 minutes remaining on your principal argument, not on your rebuttal, but on your principal argument. And then when the red light goes on, we ask you to please finish your sentence and be concluded at that time, unless there's a question from one of the judges, which you may, of course, answer. We'll go ahead and begin then with the first case on the docket, which is Garrett versus Lumpkin. It's number 22-40754. Counsel, if you'd like to begin, that's Mr. Knight on behalf of Mr. Garrett.
May it please the Court. This appeal asks the narrow question of whether the district court applied the wrong Eighth Amendment standards, contrary to controlling precedent. Because the answer to that question is yes, the proper remedy is for the court to reverse and remand for the district court to analyze Garrett's claims under the proper legal standards. I'm going to focus today on the district court's 2 legal errors. The first was applying the penological interest test from Turner versus Safley. The U.S. Supreme Court in Johnson versus California said that courts are to evaluate Eighth Amendment claims under the deliberate indifference standard rather than the penological interest test. Yet despite that clear, binding guidance, the district court, actually joining a number of other district courts in this circuit, applied Turner's test to the Eighth Amendment analysis. The second error was requiring cause.
The first error, if you're correct, that needs to be remanded. Is there enough evidence in the record for the judge to make that kind of determination?
Well, the judge might need to hear additional evidence on remand, but I think it's clear that the district court did apply this penological interest test, and typically when a district court applies the wrong legal standards, the proper remedy is to remand for it to evaluate the case under the proper standard. And if it needs to hear additional evidence, then it needs to hear additional evidence.
Is there sufficient evidence in the record now if it was remanded?
Well, I do think that there is evidence of awareness, of the TDCJ's awareness, and there's no dispute that TDCJ didn't do anything in response to Garrett's complaints to the risk of a 3.5-hour sleep schedule, which is, the district court found that Garrett can only get 3.5 hours of sleep, which is further interrupted by this bed book count, these rolling of doors, and so.
Is he the only one who complained?
So there were other complaints, but the TDCJ officials testified that there weren't a lot of other complaints. They hadn't heard that many other complaints. But that's correct, that there weren't a ton of other complaints. But the evidence does support that there was a 3.5-hour sleep schedule here. But in any event, the proper course would typically be to remand for the district court to make those fact findings that are needed.
So you're not asking us to reverse and render?
Well, I think even if the court reached the merits, it wouldn't reverse and render. It would reverse and remand for the district court to enter appropriate injunctive relief. And so I don't think rendition's really on the table here. Yeah. But the district court applied. First error was applying the penological interest test. Second error was requiring causation. And both this court and the U.S. Supreme Court have expressly rejected a causation requirement to satisfy the objective prong of the Eighth Amendment analysis. Instead, that prong requires only a substantial risk of serious harm. Yet the district court here reasoned that Garrett failed to meet his Eighth Amendment burden because at least in part, he failed to show that sleep deprivation had caused his medical conditions, again, despite binding precedent to the contrary.
Let me ask you, this may not be in the record, and you may not even know this, but maybe as part of your research in this case, are other facilities in this prison system operated on a similar, for lack of a better word, platoon-type schedule of things happening at hours that we would consider to be odd?
Well, there's some of that is in the record in the sense that there's an administrative directive that kind of gives a sample schedule. The wardens have discretion of whether to follow that sample schedule or craft their own schedule. But there are certain kind of requirements like 3 meals a day, things like that. But I do think the other prisons have at least similar schedules. I know the McConnell unit where Garrett was previously housed gave him a little bit more sleep. I think other prisons provide for a little bit more sleep as well, but there is kind of a relatively late bedtime and relatively early breakfast at most prisons, it appears.
Could he sleep between breakfast and lunch?
Well,
If he didn't have a work assignment?
Well, so the evidence shows that he did have a work assignment, that his work assignment hadn't been called up, but I think during the weekdays he had a work assignment from 6 to 2 was I think the time he testified that he had the work assignment, and TDCJ didn't dispute that, although they did say he hadn't, they weren't always called, they hadn't been called up yet. Didn't dispute that they could be called up. So the evidence was at least that that he wasn't necessarily going to be working during that time, but that he could be working. And the district court found that again the district court found 3.5 hours further disrupted, and I think there's evidence at least going both ways that that's not clearly erroneous. I don't think TDCJ's argued that that's clearly erroneous either.
Earplugs available or face masks? I know he put a towel on his face or something, but
I don't think that's in the record, Your Honor, that whether they could have gotten earplugs or face masks, maybe there's a commissary at the prison, but I don't believe that's in the record. I know he just testified that he could put a towel over his face. But I think all of these questions are on the merits. I think we would address them if we got to the merits, but the court ultimately doesn't really need to do that in this case because of the application of the wrong standards. It's routine result in these types of cases is that there's a remand. The district court makes fact findings under the proper legal standards. And so I'll go through each of these errors a little bit in a little bit more depth. First was that the district court applied, starting with the district court's application of the penological interest test. The district court concluded that Garrett didn't satisfy deliberate indifference, at least in part because it had a valid penological interest in its schedule. I think that's clear from the remand order that the district court was considering that pretty heavily. But under Johnson versus California, that was an incorrect consideration. The Supreme Court specifically said that penological interest test does not apply in the Eighth Amendment context. And this isn't a situation where the Supreme Court has given us tea leaves to decipher. Sometimes it does that. This is not that situation. It was very clear. It said, quote, "We judge violations of that amendment, being the Eighth Amendment, under the deliberate indifference standard rather than Turner's reasonably related standard." And that's bolstered by the fact that the Supreme Court has never applied Turner in the Eighth Amendment context. And so that language is binding on this court, was binding on the district court. And again, the proper result in that situation is for the district court to consider deliberate indifference under the deliberate indifference test rather than the penological interest test. And then I'll briefly talk to you about the causation standard. Again, the district court required causation, required that the sleep deprivation caused Garrett's health problems rather than just a substantial risk of serious harms. And starting again with the district court's reasoning, the district court said that Garrett hadn't met his objective prong burden because he had failed to show that there was a sufficient link that with reasonable medical probability had caused his health complaints, that the sleep deprivation had done so. And again, that's the wrong standard. This court in Ball, the Supreme Court in Helling have expressly rejected that sort of standard. An inmate only needs to show a substantial risk of serious harm. And of course, Ball's the heat case. The inmates there didn't need to show that heat was causing heat-related injury. They did have health conditions, but they didn't need to show that the heat was causing those health conditions, only that they were subject to a substantial risk of serious harm. So again, at the least, remand is appropriate.
What is the nature of the injunctive remedy that you asked the district court for?
So I think in Garrett's complaint, he's asked for 6 hours of sleep.
And how would that work? So rack time would still be 10:30, right?
I think, I mean, it could be. It could be, they could kind of stretch out the time between rack time and breakfast to provide for 6 hours of continuous sleep. Typically how that would work, though, is it would go back to the district court and there'd be a meet and confer with the state. We would talk to the state about what is, satisfies their constitutional obligations without creating an excessive burden on the state. That's under the PLRA. It has to be narrowly tailored, would be specific to Garrett.
And so just Garrett, and he would presumably have breakfast by himself?
It's possible, yeah. I mean, and it's possible that the relief that would be, not feasible. But, for example, in Ball, which is the Heat case, the district court ordered air conditioning throughout the entire prison. And this court said the finding of the Eighth Amendment violation wasn't clearly erroneous.
But Ball was a class action involving medically sensitive prisoners. Am I remembering correctly?
It was involving certainly a number of prisoners, yeah.
So obviously you have lots of plaintiffs. They're in I'm forgetting the name of that facility, but
Angola.
Thank you. We have medically sensitive people, medically sensitive problems. It makes some sense to, and hard to air condition one cell. But that's why I'm asking you if you're asking to move the breakfast time for everybody or you're trying to move breakfast time for just Mr. Garrett.
Well, I think the PLRA wouldn't allow us to get it to move it for everybody.
So it's just Mr. Garrett would have to eat differently.
At least, it would have to, unless it was completely unfeasible to only move Mr. Garrett's breakfast time. And there are different breakfast times. So,
What is breakfast time if it starts at 2 a.m.?
I think in the schedule it runs for an hour and a half. And how he testified that this happens is they come and grab people in kind of groups to go get breakfast. And it makes sense that the prison needs to run, not everybody rushing to the chow hall at the same time. But I think there are ways for the district court to craft relief that's, narrowly tailored to Mr. Garrett. And that's what the PLRA would say is required.
In your view, does the sleep need to be uninterrupted in nighttime? Like, what if they offered you, 4 hours of nap time in the middle of the day or something?
Well, I think, on the evidence we put on was about nighttime sleep. That certainly is scientifically is when people should be sleeping, should be getting continuous sleep. And I think the continuous nature is more important than the nighttime, but the nighttime is a piece of it as well. So that would be better than what he has now, but I'm not sure I'm not sure whether that would be constitutionally sufficient.
Yeah, one of the oddities that I'm struggling with in this case is that the PLRA seems pretty clear to tell us that federal judges and federal courts are not the ones that are supposed to be administering prisons.
Right.
So I can understand the nature of your claim, and everyone understands the value of sleep. On the other hand, when you come down to brass tacks about exactly how we're supposed to order the warden to do stuff, it's confusing on how we're going to square that with the general command that it's not our prison.
Right. And I think that's why they would typically go back to the district court. I think, given what we're asking for, just for a remand for application of the proper standards, that would be where it would naturally happen anyway. Even if this court were to decide that there's only one resolution under these facts on this record, it would go back to the district court, and the district court would, the state would be a part of that conversation about how this is going to happen exactly. So the relief wouldn't be just a court. I wouldn't imagine that it would just be a court ordering this particular relief because of that very concern. Well, just briefly, I will mention, again, I've been harping on remand for application of the proper standards, but if there is only one possible conclusion, the court can reach, can I think on this record say that the record establishes an Eighth Amendment violation, and I would just point to 2 or 3 facts really quickly. One is the district, or facts or findings. One is the district court's finding of 3.5 hours of sleep that's further interrupted. in Garrett 1, a panel of this court at least appeared to assume, I don't want to read too much into it, but appeared to assume that less than 4 hours of sleep Garrett was stating a constitutional claim, claiming less than 4 hours of sleep. And I think that that's an objectively sufficiently serious deprivation. Second is that the evidence is clear that sleep deprivation, and I think everybody agrees that sleep deprivation presents a substantial risk of serious harm if it's sufficiently severe. The evidence at trial was Professor Alfano. I don't think that her conclusions on sleep deprivation itself have really been challenged. And I think there's an obviousness nature here that 3 hours in sleep, 3.5 hours of sleep is.
Testimony was by deposition, right?
What's that?
Testimony of that expert was by deposition.
She testified live in the original trial.
In front of the judge.
In front of the judge, that's correct. And then finally, that the department knew about Garrett's sleep complaints. The district judge found that in her first findings of conclusions that they knew about the risk. They were aware about his complaints and the harm he claims they posed. And there's no dispute they didn't do anything about it. They've always just claimed a penological interest justification. So if this 3.5 hours does present a serious risk, I'd say there's no dispute on this record that the department was deliberately indifferent.
All right, thank you, counsel. We'll hear from Mr. Westbrook now on behalf of the defendants.
Thank you, Judge Engelhardt, and may it please the court. The TDCJ's building schedule is not violative of the Eighth Amendment, and the prison officials here do not exercise deliberate indifference by having Mr. Garrett's sleep schedule as it currently is. As such, this court should affirm the trial court's conclusion that the Eighth Amendment violation was not established.
You mentioned deliberate indifference. Are you conceding that the wrong standard was applied, but you win nonetheless under the other standard, or are you going to argue both standards?
No, Judge Engelhardt, I'm not conceding that. What we're arguing is the trial court applied deliberate indifference as well as looked to the penological interest. If you look at the first order in this case before the appeal, the judge walked the deliberate indifference there. And again, on her order on remand on page 3, Judge Ramos applied deliberate indifference and then went through and included the defense of penological interest. It is particularly interesting, before I walk into the argument of the objective and subjective prong, I'll attempt to clarify a little bit of where Johnson versus California fits into this case. So Johnson versus California, of course, is an equal protection case about racial segregation in California. And in reaching the conclusion, the U.S. Supreme Court walked through and addressed different standards that are applied in the prison context, specifically the Eighth Amendment, and referencing Hope versus Pelzer on appeal to that court from this court. This court in Hope looked at wholly without penological interest as part of the Eighth Amendment claim. And that really ties in the context that prison officials can't have an Eighth Amendment violation if there is some penological interest at play there. But the specific standard that was applied in Hope goes back to Farmer and Estelle versus Gamble, that deliberate indifference standard of asking first the objective question, was there a sufficiently serious risk of harm at play by the policies in the prison? And second, did those prison officials on the subjective standard have deliberate indifference, specifically down the line of looking at whether or not they actually knew and understood the risks based on the fact, and then drew an inference from that what they were doing was deliberately indifferent to harm. And as a trial judge in her first order noted, there's this third prong coming from Farmer that asks also the reasonableness of the actions that were taken in that context. And if you want to look specifically at this undue penological interest question in Hope, it's right at page 738, and the court applies it again at 745, talking about the amicus brief in this court from the USDOJ in Hope versus Pelzer. But turning back to the standard at play here for deliberate indifference, is that deliberate indifference first asks that objective question, whether or not there's a sufficient risk of serious harm. And here, I believe there are about 4 different issues that are being asked here, or 4 different issues that are arising to allegedly deliberate or constitutional violative conditions. First, we have the lights and sounds in the prison made by inmates, the lights of the prison itself operating, the sounds of the operation of the prison, and then the sleep schedule. I'll walk through each of those in turn. First, with the lights, Judge Clement, to your question earlier, I know that in the trial court, in the testimony of the McConnell unit, Mr. Garrett was able to purchase face masks from commissary. I believe those conditions are the exact same in the Estelle unit. But the other interesting fact here is that Mr. Garrett testified his deposition that he can turn the lights on and off in his cell here in this context. It's a manual switch. And he also recognizes that you can't turn the lights off around the prison for security purposes. Next, this court in Walker versus Nunn going to the operation of the prison, those opening and closing of the gates on an hourly basis. While there isn't sound dampening in the Estelle unit, it's an older prison than the McConnell unit, it does require the prison to operate and let people in and out of the cell blocks every single time. I think they go about hourly to walk through there and open them. I'm not specific on how many times a day those doors are open. And third, the noise of the other inmates. That in of itself wouldn't be a constitutional violation of inmates seeing if Mr. Garrett's awake or not. And now turning to the sleep schedule itself,
Why is a 2 a.m. breakfast necessary?
It's necessary, Your Honor, because there are several different shifts of inmates based on classification. Mr. Garrett, I believe, is a G2 classification in this prison. You have other inmates that are administrative segregation, other wings that have to roll through, and just for the operation of the prison itself, of having to feed, I think in Estelle, there's 2,800 inmates, maybe 2,200 inmates. There's a differentiation on that between prison systems, but you have to get all of them through the chow hall, have them eat lunch or breakfast, lunch, and dinner, and as well as you have inmates coming in and out all throughout the day. So that requires at least a schedule for this wing itself is going through at a certain time of day.
Is there a reason that they can't have rack time that's earlier, given that they wake up at 2 in the morning?
I believe the reason rack time is at 10:30 at night is because Estelle's medical mission, the coming and going of offenders throughout the state, maybe they're off at UTMB, maybe they're somewhere else. So that rack time allows the prison officials to have a cutoff to know when people are where they're supposed to be, Judge Oldham.
What is the director's view about the constitutionally minimum time that a prisoner gets to go to sleep?
I don't believe that Director Martinez, or Director Lumpkin, has a specific view on the constitutional minimum of sleep. I know for a fact there's no policy from TDCJ about the requisite amount of sleep, but I want to clarify or specify one thing. Mr. Garrett's in a cell 13 and a half to 15 hours a day. Inmates in their trial testimony below that were called as witnesses by Mr. Garrett noted that they sleep throughout the day whenever they have the opportunity. So that 3.5 hour window at 10:30 till 2 a.m. is not necessarily the only time someone has to sleep in a prison.
Well, if you left a prisoner in a cell for 15 hours a day with the lights on and music blaring, would that meet the sleep? Well, let's make it easy. Let's make it 24 hours a day. So bright lights and music and loud music for 24 hours a day. Does that meet the constitutional minimum?
I think that would. If you have an individual in a cell, bright lights blaring nonstop, no ability to cover their eyes, no ability to turn off the music, and keeping them intentionally awake all day long, I believe that would be a constitutional violation, but that's what we have here.
And that's helpful because I'm taking the premise of that answer is that you agree that the Eighth Amendment somehow charges federal courts with determining the minimum amounts of sleep that prisoners get.
I would agree that the federal courts do have that power under the Eighth Amendment. We see that across time. This court has looked at it before, Walker versus Nunn, other cases with sleep. So I think that's a well-taken point, Your Honor.
So we have the power to make an Eighth Amendment rule. We know that 0 is unconstitutional, but the director's view is that 3.5 is constitutional. So it's somewhere between 0 and 3.5 is the right line?
I think it would be, if we're looking in isolation, that's all that there is. I think that would be part of the view on that context, that if there's only ever allowed to have that opportunity to sleep, but that's not what we have at play here, Your Honor. There's a time throughout the day for individuals to go through. And even in the afternoons, Mr. Garrett isn't filled with activities every 15 minutes of the day. The record yields to us that on Wednesdays and Thursdays, he'll go to recreational activities. Tuesdays and Wednesdays, he'll go to recreational activities. Thursdays and Fridays, he'll go to religious activities along that time. So that's between 2 and 6 p.m. He doesn't turn out for a work crew, so if he were to wake up and be prepared, go to breakfast at 2 a.m., and then he was to be able to go somewhere else, he would have time to return to his cell and sleep.
Does he have the ability to opt out of any of those activities during the day, the ones you just mentioned?
Yes, Your Honor, his ability to opt out. Those are his choices to go partake in veterans' activities, religious activities. By no means are we saying that one should have to be forced to do that, but he has the opportunity to opt out of those, much as he does with recreational time. He doesn't go and turn out for recreation itself being physical activity. Same thing with whether or not if he wants to snack throughout the day along those lines. And I want to just I think we've covered the objective prong itself. There is adequate time throughout the day. There's, more importantly, the subjective prong of the deliberate indifference standard, that somebody has to somebody being the prison officials, from the facts present, draw that deliberate indifference to an individual that they do not have the constitutional mental sleep, and they're intentionally, not intentionally, but knowingly violating that constitutional right. And there's no evidence here in the record of that violative action or that inference being drawn here. So simply look at the pieces of evidence my friends on the other side have put on. One of those is the KOP order, that keep on person order. It's a little unclear in the briefing itself, and I want to specify that a KOP program itself, so the Manual 27.1DI, that program is made in conjunction with UTMB, a separate government entity, and TDCJ. But the individual directives of who has a KOP order, from my understanding, is determined by UTMB physicians, and the prison officials who explained in the brief wouldn't have specific access to that information of why someone has a KOP order. It may be the necessity of having to have a medication on them at all times or something along those lines. But there's no subjective knowledge drawn from the KOP order that the prison itself knew that Mr. Garrett had that, even if he did for a lack of sleep. And turning...
Why can't they rotate these breakfast assignments? Why would he always have to go at 2 o'clock? If they have groups going at different times, just rotate the groups.
And Your Honor, I'm not certainly clear on that, on the time to move the different breakfast schedules itself. It seems to be that they've been set up in this way at most prisons across the state. This is just when this specific unit and the schedule that they're on when they're reviewed annually. I'm not aware of any discussion in the record about whether or not those could be moved if they're in a specific reason because of the offender type or because of the way the prison needs to run to get people ready for work turnout assignments, medically, things along those lines. But I'm not specifically sure on if other prisons do, in fact, rotate breakfast schedules. And then turning next to the knowledge of Warden Lamb. Warden Lamb didn't have subjective knowledge of any sleep complaints. He noted in his deposition or explained that the first time he learned of this was through preparation for the deposition after receiving the deposition notice. And then finally turning around to Mr. Garrett's multiple grievances. This court, even in Ball versus LeBlanc, noted that those individual grievances filed by an offender or those I-60s themselves are not evidence to demonstrate and provide subjective awareness to a prison official.
But presumably, Director Lumpkin and people in his chain of command know about this person and his complaints because he's been to this court and won. So it's not just like a random PLRA grievance that, and of course we wouldn't attribute knowledge of that to anybody, but it would be quite something to say the same prisoner who's been to the Fifth Circuit and won some form of interim relief and gone back and it's been going on for 10 years, we presume you have to give us some knowledge, right, attributed to the prison officials about the nature of the complaint.
Well, no, Judge Oldham, not specifically, because both times in the trial court in this case, or actually all 3 times, the trial judges concluded the prison schedules themselves are not violative, specifically both in the first appeal from the full bench trial and then on the next, or excuse me, the full trial, and then on the order on remand, the judge concluded these schedules are not violative of the 8th Amendment. I think it would be interesting to say that a person can, almost like the tail wagging the dog, that by filing the lawsuit, surviving 12b-6, and going to a bench trial and getting remanded for mootness would be, or an investigation of mootness would be enough to show subjective knowledge of a violative 8th Amendment condition.
So I see. So your point is not that they're not unaware of the complaints. You're just saying that they're unaware that they're violating the 8th Amendment because they haven't lost yet.
I think
it's almost like a qualified immunity sort of clearly established thing. Is that the gist of what you're arguing?
I think it'd be something akin to that, Your Honor. I think it would be not specifically the qualified immunity analysis. There's no well-pleaded case here. But I think it would be the context of these prison schedules have been tried in court before and they've not been concluded to be violent of the 8th Amendment. It would be a far stretch to say that just the fact of having ongoing litigation would reach the level of subjective knowledge, or even that they drew an inference of their actions, the officials drew an inference of their actions were violating Mr. Garrett's 8th Amendment rights. And that really turns again also to where that reasonableness prong pops in here one more time. That when these prison officials are drawing their inferences, the facts were established specifically that maybe or maybe not the schedule could violate the 8th Amendment. We believe that it doesn't, as a trial court concluded. That the facts and actions that were done by the prison officials themselves they're intentionally done with knowingly done with deliberate indifference to violate an individual's right. Again, the prison officials here, they have 2,800-ish inmates that are in a prison that are operating on this schedule, very few complaints across the board, as well as they see inmates throughout the day sleeping in their cells whenever they have the opportunity. It'd be a far stretch to say that the inference that was drawn was unreasonable, and that's what the court instructed in Farmer versus Brennan, and again, Hope versus Pellsford, that when you're drawing the subjective knowledge, that there's a reasonableness component that's applied. And again, that goes to why the trial court's order should be affirmed, that even if this court concludes that Judge Ramos applied in part the deliverance indifference, the penological interest standard, she still walked through, although it cursory and short in both her first and second order, Farmer versus Brennan's two-step analysis of objective versus subjective, and she also included on the end that penological interest test, and that seems to be something that across the board has been applied. Also by this court, most recently, this court had a case come down in June in Jarvis versus Hall, where as part of that analysis of conditions of confinement's claim, and that's 2023 Westlaw 3818377. I apologize, I found it this morning for not filing a supplemental pleading on that, or supplemental letter. But this court walked through deliberate indifference, objective, subjective, and then included as part of that Rhodes versus Chapman, as well as Gregg versus Georgia discussion, that there is a penological part, a reasonableness part that should be applied. And that's really at the heart of this matter here. The trial judge or district court walked through deliberate indifference, applied both and concluded that there was not an objective violation of the Eighth Amendment, as well as concluded that prison officials were not subjectively aware, and additionally add in that penological interest. So at that point, this court should affirm. Questions?
I wanted to make sure
Yes,
you
Your
got
Honor.
out the full argument before I circled back to this, but I want to make, I realize that you didn't write the brief that's in front of us, but the brief that's in front of us from the director harps very hard on the point that you've made this morning, which is, well, 13 to 15 hours in the cell should count in the Eighth Amendment question. But I thought what we talked about earlier is that if you gave 13 to 15 hours in a cell, bright lights, louts, and noise, that would not count. So I'm trying to figure out what the relevance is of the 13 to 15 hours in the cell during the middle of the day, not at night.
And that would go to the type of noise and type of lights. The lights Mr. Garrett can turn off in his cell, so that would alleviate that one, or as well cover his eyes to alleviate that. The other aspect is not, and I took the premise of your question, Judge Oldham, to be that you were asking that the prison officials were forcing this loud music and this loud discussion, almost in the context of what we might think of sound torture, of forcing them to be blaring music all day long, every second of every day. But here, Mr. Garrett's loud sounds during the day are one, the regular operating of the prison, which he experiences throughout the night and the day as well, and then the sounds of other inmates. I believe we quoted in our red brief here that Mr. Garrett noted that people will try to talk to him throughout the day and he won't be awake because he's sleeping. I may be misquoting that specifically, but it's in our red brief here that he does have the opportunity throughout the day.
And is the director's position that whatever is going on with respect to either normal prison operations, even if that's the so-called loud banging or whatever he describes of the door slamming and all the rest of that, that's not attributable to the director for the Eighth Amendment purposes?
No, Your Honor, that's just the reasonable operation of a prison itself. We have to have inmates coming and going throughout the day, and the prison itself requires opening those doors on different cell blocks, especially as well as when the guards go through and do that standard count where they walk by and see a living, breathing person. And that does bring up that one point on the rat count happening during the night, the bed book count. There's, again, an additional purpose of that, as Director Martinez testified in his deposition, and I believe also at trial, as well as Warden Lamb testified, that you have to have the count every, I believe it's 4 hours in this prison. It may be different if they're having a special count, to see one, a living, breathing body, identify them, have them stand up and give their ID and their TDCJ name and number, because you want to see, one, they're not injured, dead, suicide, or as well as they haven't somehow replaced their person with another inmate or prison guard. And additionally, in the context of these prisoners do have some free flow when they're coming and going from activities, to make sure that they've returned at the right time, that they're in their cell when they're supposed to be. Maybe they were out somewhere else during the day, or that's about it.
Who controls the loud music?
The loud music is the other inmates are playing it throughout the day, Your Honor.
They have radios.
Yes, Your Honor. I believe they have radios here. They have the ability. There's also a recreational room here as well.
Why can't the prison turn down the music?
The prison, I believe, we cited in our red brief a policy in the 1990s that hasn't been in place since for this music, but that's also just during the day. From my understanding of the record, they're not blaring the music throughout the night once they've racked up at 10:30. So it's just throughout the day and having inmates going through and having their regular recreational time in the day room or something along those lines. If there are no other questions, I'll see the remainder of my time.
Okay, thank you, counsel.
Thank you.
Mr. Knight, you've reserved 5 minutes for rebuttal.
May it please the court. I just want to address a few points quickly in rebuttal. First, my friend on the other side talked about each condition independently, and the Supreme Court in Wilson versus Seiter has said that you got to consider all the conditions together, because that's what they're really, the prisoner is really experiencing, is all these conditions together. I would note that on the sound, the prison absolutely has control over, telling the prisoners to turn off loud sounds or to stop screaming. The prisoners, can't just do that stuff without being subject to discipline. I can't recall the case off the top of my head, but there is a case about an inmate in a psych ward where the prisoners next to him are screaming and he can't sleep and he's being totally disrupted by these other prisoners, and the court there considered that as, and I'm sorry, I can file that as a supplemental if the court would like, but that's absolutely relevant. And then second, on knowledge and deliberate indifference, I think I heard suggested that the prison can avoid knowledge or deliberate indifference just because it denies that a risk exists, and that's not what the case law says. Is you can't, the prison can't put its head in the sand, can't avoid knowledge of obvious risk. Farmer says that. I think that's pretty commonsensical, that it can't just say that this bad thing is happening, but that's not a risk, so we don't have to deal with it. And then finally, there was a lot of discussion about the facts, and we do think that on this record that Garrett can be entitled to relief. But ultimately, the court really only needs three things to resolve this case and to send it back to the district court. And one is the remand order, which shows that the district court applied two incorrect standards. The other is Ball, which says that causation is not the correct standard under the objective prong. And the third is Johnson, which says that the penological interest test does not apply. So unless the court has any further questions. Thank you.
Okay, thank you, counsel. We appreciate your briefing in this case and your arguments here this morning. The case will be considered submitted.